Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to the show. My name is John Roberti. Today's episode is Privacy for the General Public, the expansion of privacy regulation in California and beyond. Privacy law is becoming increasingly important here in the United States. It's something that folks in Europe have known about for a long time, but I think we in the United States are really just getting our arms around what it is and why it's important to us. And there's more privacy to come. So we want to talk today about what is the regulation in California going to look like? How is it going to affect the whole country? My co-host today is Anora Wang. Hi, Anora.
Hi, John.
Anora, why are the developments in California important for us to learn about today?
Well, it seems that California has come out as a leader in the issue of regulating data collection and data use, while some other states and maybe even the federal government is considering making new privacy laws.
And who is our guest today?
Well, today we have Alysa Hutnik. Alysa is the Consumer Protection Officer for the ABA's Antitrust Law Section, and she is also a partner at the law firm Cali Dreyer and Warren LLP.
Anora, what do we want to get out of today's conversation with Alysa?
We want to learn about what is CCPA. Maybe Alysa can start telling us what CCPA stands for, and then why and how it relates to other laws that might have already touched the issues of privacy and data.
Great. Well, let's bring in our guest. Alysa Hutnik, welcome to the program.
Hello. I'm so happy to be here. Thank you.
So, Alysa, first question for you. In plain languages, what does the CCPA provide for consumers, and what is CCPA?
So CCPA, not to be confused with TCPA and a ton of other acronyms we have. California Consumer Privacy Act of 2018. It is one of the leading, because it was the first one that really got passed, of a comprehensive privacy law regulating online and offline personal information of consumers.
Well, are there any gaps that CCPA is intended to fill? Since, as I already spoiler alert a little bit, there are other laws that also touch the issues of data and privacy.
So maybe we might take a couple steps back. In the U.S., we're very sector specific, right? So we've got a bunch of federal laws that regulate specific data or specific industries, like, for example, HIPAA for health information or COPPA for children's information. And the states have really picked up in response to that in an incremental way. So they had privacy-related laws where you had a post-to-privacy policy online. They certainly had plenty of data breach notification laws. But now, rather than an incremental baby step, what California did with CCPA is they developed a comprehensive online-offline type of privacy law that not only regulates what companies have to say to consumers about their data practices, but actually give also some obligations on what to do in response to certain consumer requests and rights.
Is it fair to say that consumers now have more protection in the front end, and maybe in the back end they also have a right to sue?
So we're gonna break that up a little bit. Do consumers have more protection? And I think some of that depends on the eye of the beholder, right? So there's certainly, what CCPA does is underscore, perhaps put onto steroids, some of the disclosures that companies have to provide about their data practices. And the intent is to empower consumers to be able to ask the right questions, to get information, to make decisions about how they want their information used. Does it put more protection rights than they have now? I think it's what we don't know yet is what are the consequences to a comprehensive law like CCPA in terms of how companies will respond and make decisions. So that's a big open-ended question.
What about the back end? Do consumers have a right to sue?
So they do have a right to sue, but on a narrow basis. And this was a really big deal because unlike GDPR in Europe, that's Europe's comprehensive privacy law, which had a 2-year time span for companies to get into compliance, CCPA was a very compressed timeline. It was a ballot initiative headed off by this very quickly drafted legislation that got signed in. Consumers, so there was kind of a bit of a compromise there, and so the private right of action was pretty narrow, and related to data breach notification. But what we've seen is a ton of attempts at amendments, and so that's where I think a lot of companies are watching. There was one amendment that attempted to broaden the private right of action to any type of privacy stake, essentially in the legislation, and that seems to be dead at this point. That legislation did not move forward. Never say never, because it's technically possible whether it could come up again, but it remains to be seen. At least for now, I would say it remains with a narrow private right of action to data breaches.
Right. So no matter who can sue, maybe let's talk about some, what are the harms that, that's recognized in the law. So so far I understand that the FTC has done some work in the past years with regard to informational injuries. Does the CCPA go beyond that?
So that's interesting. Maybe to unpack that a little bit, the Federal Trade Commission has really looked at, are harms purely economic? Is there some other type of harm like informational harms where somebody's reputation or there's emotional damage? The CCPA does not quite address that yet. And I say yet because like any law, we want to see how it gets pressure tested with litigation attempts. I would imagine that there could be opportunities that plaintiffs might try to use is there a standard of care? And then looking at what kind of damages there are to try to prove up or try to poke some extra air into that narrow private right of action. But that's remains to be seen.
Right. So, Alysa, if as a consumer sitting in Washington, D.C., how, if at all, is the CCPA going to affect me?
Well, it's not going to affect you directly, but it will affect you. And here's why. We saw many of us got those emails around the prior May saying, we've updated our privacy policy. We've updated our terms of use. You might have received many of those, right? And that was because in response to GDPR, companies had to update and give more notices. And they weren't going to do something just for the EU. Some companies decided to do that globally. And I think similarly with CCPA, you're going to have companies, some are going to decide that it's not possible to have a California-specific type of practice, but for everybody else, I'll do something national standard. I think you're having a lot of companies who are going to decide, I'm going to take this California approach and I'm going to apply it nationally. And so there's going to be updates to privacy policies for those that read them. And there may be a national application of some of the privacy rights that are set forth in CCPA that could be applied in practice to a DC resident or a Virginia resident or, Kansas City resident.
Let's unpack a little bit. What's exactly the California approach? So there are terms that, that has been floating around, like FTC has something called notice and choice. That's the prior paradigm, I suppose, and the California approach is different than that. Is that right?
Yes and no. So notice and choice is essentially the concept of I am going to have clear disclosures in a privacy policy, and you have a choice to opt out in response to that. CCPA also has an opt-out approach to things in large part. There's a narrow exception there for youth data, tween data. But essentially it's updating the disclosures in the privacy policy, giving you the choice to opt out. That's different than GDPR, which is an opt-in type of framework. The difference, though, is that by statute, what CCPA does is give the consumers a lot more visibility and rights. So unlike a scenario where we have today, where a consumer can look to the privacy policy and read that, and their only action they could take is to opt out, under CCPA, they might be able to go to the company and say, I want the data that you have on me. And the company then has an obligation to provide that type of data. So there's a transparency element that we don't quite have under today's standards. And then the consumer has more information to be able to make some choices. I think it also remains to be seen if companies have to be so transparent about their practices, might that influence some of the decisions that they make about how they use and process data?
Give us an example of a decision that could get impacted.
Well, there's the big one right now really is, think about advertising. So the internet as we know it, we have a lot of free models where I can, listen to stream movies and stream some songs or little clips, and I don't have to pay for that because it's ad supported. So one of the big things about CCPA is it has this definition of sale. Am I selling you data to a third party? You're not my service provider. I'm going to sell it to you. Well, how do you take that broad term and apply it in the context of ad tech, right? Where data, and it's not your name necessarily, but it is certainly information about your profile that allows targeted advertising to you. If that is defined and gets encompassed as part of a sale, that's going to probably change some of that ecosystem in terms of what it looks like today versus what it might look like in the future.
What would happen if the companies don't comply? Are they going to get hefty fines like the GDPR imposes? So
there is an enforcement mechanism. And the California Attorney General certainly has the ability to levy fines. I don't think that's first on the list of what the California Attorney General is going to do because that office also has its own deadlines and it has to issue regulations. And so that's something that we're very much going to be looking to help understand the CCPA better. And generally, I would imagine that the Attorney General there is going to be focusing on the regulations first, getting some business guidance out first before we start seeing enforcement and with fines levied.
Alysa, where did this come from?
Well, this is, as a privacy lawyer, this is a really exciting time because every day you look at the newspapers, right? There is a data breach, there's a privacy snafu. And I think so much of it really comes to the underscoring of we are all online. So much of our interactions are online. It's all about the data. Our homes are now smart. We have our smartphones and usually smart tablets and smart TVs and all sorts of devices that are collecting all types of data about us. And because of that, there is so much more of an emphasis on, well, what kind of data are companies collecting on me? And so in response to what we saw in Europe, that I think it really elevated the discussion of privacy and consumer protection and where do we want to calibrate those rights and choices here in the U.S. And so in large part, I think it's the shorter answer is probably the rise of and development of technology as it relates to data. And if Europe's talking about all these privacy rights and giving all these privacy rights, are we so different? And if we are different, why? How so? And that's really been, I think, a big part of that discussion.
Well, do you think that we Americans just don't get privacy in the same way that the Europeans do?
Well, I don't know that it's the Americans don't get privacy. I think that there is a balancing that we are trying to strike here in that data protection in the EU is the fundamental right? It's data protection first before you get into some of these other concepts. And in the United States, we've got the First Amendment. So right there, that's a big distinction. But we also have emphasized this entrepreneurial aspect to our country, right? That's such a key principle. And so from the competition side, from the innovation side, when you prioritize data protection first, that cuts down on data flows. And so it has consequences. All of this is you make a choice and there are consequences. And so if you're going to restrict data flows, then that will have that bit of a domino effect. And in the U.S., we are trying to figure out where, yes, we value privacy, but at what expense? And is there a better balance to strike that might be something different than the GDPR?
In a sense, and again, I'm not a privacy lawyer, so I may be wrong about this, but my sense has been that the privacy was very much a very lightly regulated space. The FTC tried to get into that space a bit through Section 5. The states were all kind of doing their own thing, but generally, as you said, pretty industry specific. Is this California law going to be the thing that starts to fill in that gap in our privacy regulation?
If you asked me maybe 6 months ago, 12 months ago, I may have had a different answer. I think to your first point, you're right. I mean, privacy really was lightly regulated, and I think as more things moved online, and the use of data, the collection of data, the personalized experiences, and the profiling got so sophisticated, I think there were questions about is the privacy policy enough to really put consumers on notice and give meaningful opportunities to make a choice? Or does that choice become too complex? And so, periodically there were attempts we would see that maybe there's draft federal legislation, but there was no real momentum. And so you saw scenarios where states were not going to wait for the federal government to figure it out, and they were going to move ahead. And so California, first to do that, they did that with data breach notification too. They were the first to lead that charge, and that ultimately became largely the standard for the United States. I mean, certainly there are other states all other states have a data breach notification law with some variances, but California was the first to start. So the question is the California law going to be the standard that we will regulate privacy in the U.S.? And I think for starters, probably to start with, certainly other states have various draft legislation that also is working their way forward. I raised the question, though, unlike data breach notification law, which is really about harmonizing a notice that complied with all states, how do you harmonize operational processes that are subject to differing and potentially conflicting laws?
And so imagine if we have another 10, 12, 15 states that all pass their own privacy legislation. Doesn't the regulation become the floor for each?
It does, because you have, as a practical matter, most companies are going to say, well, I'm not going to have different processes for one state versus another state. What is the most rigorous? That's what we're going to have to do to manage our compliance obligations and go to that standard. It's a question as to whether that, depending on what that standard looks like, might motivate federal legislation.
But also, what about compliance cost? Imagine there are like 10 to 15 different standards, and even maybe a company would choose one, the lowest or the most strict. But there is a question of cost, and does that affect maybe innovation? Like, the company would not get as much use of the data as they wanted?
Costs of compliance and innovation are so central to these questions, right? Is there a way that you can comply? Is there a way that we can interpret this that still allows the viability of some business models? So I think there are certainly aspects of that are going to change. And are there ideas that might never make it to fruition on the innovation front because of the new risks posed by this law, California law, and other laws? I think that's a real good question. It's something that commentators have talked about in terms of GDPR and companies pulling out entirely of Europe for that reason, or doing a different type of practice in the EU. And I think you probably will see some variation and experimentation by companies, both balancing the cost of compliance with the ability to innovate and offer services. And so that is another one of those we're going to watch and see, but certainly a factor that companies are taking into account very seriously.
So what's the fix?
What is the fix? The fix is there's going to be experimenting, and can we get to the right calibrated result? I mean, right now in Avoid, there's been a lot of discussion over from the FTC and from others of, yes, we need to improve on this notice and choice. Maybe that isn't working anymore. There should be something else. Maybe it's more accountability. Maybe it's much more processes that are spelled out. There's certainly a lot of drafts of federal legislation that try to talk about that. One of the things that I am looking for is what the FTC is going to be commenting on this point. So for now, the FTC has said, privacy law, it's a social, cultural type of issue. I defer to Congress. But meantime, they have been holding these historic hearings that have brought in a diversity of viewpoints, have commenters, have comments filed, looking at various issues of privacy and competition. And we expect some forthcoming reports that will try, I think, to speak to the competition considerations. And so that way, whatever outgoing report will come from that, I think it will inform the conversation, whether it's ultimately at the congressional level, ultimately in criticism or supplementing some of the state laws that are going to be on the books.
Well, if Congress were to pass a comprehensive privacy law, would that make the CCPA less relevant?
Oh, it depends, right? Because one of the bargaining chips is, will there be preemption, or will this be added on top of everything else? And so that is a big question. I think we've seen other examples where preemption it was such a hot button issue, it either didn't get addressed in the legislation, and therefore the litigation had to really resolve that over many years, or if it did get addressed in the legislation, the language had some room in there to test it out, and we still saw litigation. So I think whatever happens, there's not going to be a clean answer either way.
I just have two more questions, more specifically towards CCPA. So it looks like maybe I'm not reading it correctly. CCPA seems to have narrowly focused on the sale of information, or however sale is defined. Is that right? And why is that?
I think it's broader. Two things. One, CCPA did talk about service providers. So thinking about your internal, whether it's you doing it yourself as a company or you are hiring others to assist you, CCPA absolutely talked about that. And to even meet that definition of a service provider, you have to address very specific things in that contract. And if you do, there is somewhat of a safe harbor in terms of vicarious liability if that service provider does something wrong. So I think it certainly speaks to the internal, and there's a lot of exceptions that also speak to when something is not a sale because they're happening internally, or right to deletion opportunities where you, as a company, you might not need to delete certain data for internal purposes. Sale, though, in dealing with third parties was a big part of this, because if the intent is to create more transparency around data sharing and data processing with third parties, there's a lot of big emphasis on that term and what qualifies as sale.
Right. So the other question I have is that it seems like the CCP has granted a rulemaking power to the California AG. What's the more profound implication of that?
Well, right now we have a statute that needed to head off a ballot pass. So it was very quickly drafted, and there are some issues with it. There are some self-recognized issues, things that don't quite make sense, that needed to get cleaned up. What the Attorney General regulations are intended to do is, A, clarify some of those definitions, like personal information. Well, that's the pivotal definition, right? If it's not personal information, then it's not going to be subject to all of these restrictions. So I think absolutely want to know what that regulation will ultimately look like. But the Attorney General also has powers to issue other types of regulations as well as business guidance. So all of those types of pointers that we are going to get will certainly shape how compliance programs look.
Right. I just have one last question that's not substantive. You obviously love consumer protection law and you have a lot of passion for it. Why is that? What makes consumer protection fun for you?
That is a great question. We are all consumers, right? I buy my smart products and I go to websites and I have data collected. And I think the empowerment of being able to really try to understand this messy gray area of the law and help working with companies who want to do the right thing where there are not clear answers, and getting to work with companies to really creatively solve those problems. So I feel really blessed to have that opportunity.
That's great.
So I think our listeners maybe would like to know a little bit more about you. So can I ask you, tell us something surprising or unusual about yourself that we wouldn't know.
I grew up in Los Angeles. So that's not the big exciting part.
It's actually a fairly big city, so you're not alone in doing that.
I grew up in Encino, a location of many movies, including Encino Man. I would not call myself a Valley girl, but others might. And I was in a game show when I was a teenager, and I had slime poured on me.
Really? What game show was that?
It was Funhouse. This was the Fox competitor to Double Dare.
Interesting. How'd you do?
I won.
And what was the prize?
The prize was, believe it or not, there were various things, but one which I was so excited about was a CD player that, I kid you not, was the size of like one of those old televisions.
Oh my.
That you could put CDs in. That is,
did it have like a crank that you could turn?
Pretty much. Yeah. I was so excited to get that. I got a free limo ride to my school, which was not something that in the school area where I went to, you'd want to show up in a limo. So
interesting. Did they have a parade or anything like that?
No parade. No. In fact, I was desperate not to have any of my friends watch the show. I just wanted to win and have that done in secret. But of course, a lot of peers watch Funhouse in the morning as they're eating breakfast. So I had plenty of friends who saw slime poured on me.
Interesting. Well, now that we know that about you, I think it's time for a segment of the show that we call The Curious Hat.
And now it's time for The Curious Hat.
So, Alysa, with The Curious Hat, we have a bunch of index cards in a hat. You pick it out, hand it to me, and I will ask you the question on it, and then I get to ask you a follow-up question, too. Okay. Which one? That one? Okay. Okay. This is a good question. If you couldn't be a consumer protection lawyer, or any sort of lawyer, what would you be?
This is what I would be. I would be a writer. I love writing, so I'd be a fiction writer. But I wouldn't just do that, because you can't. What do you do when you have, you're in a time? You can't figure out that story. I love to bake, and my husband loves to make jam. So I'd bake the sweets. He would make the jam. We'd do our thing.
You'd have like a jelly sandwich shop.
Jelly sandwich shop, exactly.
Interesting. All right. So here's the follow-up question. When you were 5, let's say, what did you tell people you were going to be when you grew up?
What did I tell people? I thought probably an actress.
Not the jelly thing?
No, there's a lot of home videos with me with my fake microphone, either a newscaster, actress, what have you. But yeah.
Any videos involving slime?
That came later. And it comes full circle, because my daughter's birthday party is coming up, and we are having a slime party.
On that note, that is the end of our show. Thanks again, Alysa, for joining us. We will be back next week with our next episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by the ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust Section has to offer at ambar.org/antitrust. If you have suggestions for topics or are interested in participating in a future episode, please reach out to us at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.